was eject.
Victor 40, take
It's
one.
never meant to be comedy.
And I felt it there.
Yeah.
It's like, oh, I see it now.
Yeah, that's all they're supposed to
Okay,
do.
ready, everyone?
It's to communicate.
Talking at the bar, something's on the screen.
And can you give us a couple cues of like they score? Just so everyone else around us is having a moment.
But is it as rambunctious as it was earlier on?
No, it's never going to be because we're in slow-mo. But just they're watching, people are watching games. We see some, just some hands and things like that. Yeah, thank you.
Ready, and everybody good? And playback.
Welcome back, everyone. Something new just came to light in court, and it involves Jed Wallace. It got me thinking about his case, especially since Blake's lawsuit against him was dismissed. When the judge dismissed it, they clarified that Blake could only refile the case in New York if she could prove that Jed's actions were specifically directed at New York and caused her harm there. But she doesn't have any such evidence. The judge did mention she could pursue the case in another jurisdiction, like Texas. Now, I've explained before that there are complications if she tries to file in Texas. There are some real obstacles she'd face, especially if she wants to countersue him there. So I went back to the beginning. While we were working with various lawyers on this whole situation involving creators, it became clear to me that Blake's legal team is now trying to distance themselves from the Jed narrative. They're downplaying his role, suggesting he wasn't the only one involved in the alleged smear campaign. They're trying to make it seem like it was a group effort, not just Jed acting alone. That shift made me feel like she probably won't refile against him. Just a gut feeling. I mentioned that to you yesterday, but as I reviewed the original deposition notice she sent to Jed, I found something very important. Plus, a newly unsealed document came out just yesterday, and it's revealing. This unsealed document shows that Jed Wallace was fully aware of a 17-point agreement. However, that agreement doesn't state any harassment occurred. It's just a list of conditions Blake required in order to return to work. In fact, an email from Melissa Nathan to Jed outlines these exact points, saying, "These are the terms Blake insists on before coming back to set." It lists all 17 requirements. While some details differ slightly from the final version, likely a red-line draft, it clearly includes a non-disparagement clause. That clause states there can be no retaliation of any kind against Blake for raising concerns or for making these demands. It even says things like sarcasm, marginalization, or any negative attitude on set or during promotional work would be seen as retaliation, and that such behavior would be met with immediate action. What stands out here is how broad this clause is. It goes beyond standard federal retaliation and harassment protections. It implies that even tone, sarcasm, or offhand comments could be considered violations. But again, let's be clear. Nowhere in the document is there a direct claim of sexual harassment. It's strictly a list of Blake's work conditions. Some of her requests include having creative control and bringing in personnel to address creative issues. To give examples, points 10, 11, and 12 are about creative disagreements. Point 8 discusses COVID protocols, unrelated to harassment. Point 1 refers to an intimacy coordinator and closed sets, nothing suggesting misconduct. There's also a request to avoid spontaneous improvisation of scenes. So again, while the document sets very firm boundaries, it doesn't accuse anyone of sexual harassment. It's a work agreement detailing the terms under which she'd return to set. Anyone looking at this would see that she is essentially restricting the ability to even discuss creative differences, which, to be clear, is not covered under retaliation laws related to sexual harassment. Nevertheless, she included a clause that effectively limits and silences any kind of speech regarding Wayfair. It's a broad and aggressive non-disparagement agreement, one that's also vague and potentially contestable in court. This non-retaliation clause could play a role in the defense, particularly in determining whether it's even enforceable under current law. The question is whether it extends beyond what federal law allows in terms of retaliation and sexual harassment protections. Crucially, Blake never filed a complaint with the EEOC. Without doing so, she can invoke certain protections under EEOC regulations. Still, what's important here is that Jed was aware this non-disparagement agreement existed. That awareness aligns with his claim that he took a passive approach, and it may also explain why Wayfair didn't respond to media inquiries. They knew about the agreement and likely wanted to avoid violating it. After all, why would they risk publicly disparaging the lead actress in their own film? It would only harm their project. It seems that leaks came from both sides. Blake Lively's team, via Leslie, leaked information to the press, while Stephanie Jones, a publicist for Justin Baldoni and Wayfair at the time, pushed a narrative blaming Blake. What's key here is that this non-disparagement agreement is so sweeping that it could encompass any negative comment about her, regardless of context. She's framing any criticism as a violation of the protective terms she claims were put in place when she returned to work. But those terms are ambiguous at best. Now, why is she not pursuing a claim directly against Mr. Wallace? Likely because back in January, she filed a notice of deposition for Jed. In that filing, she alleged that the retaliation campaign involved more than just PR professionals and crisis managers. It also included subcontractors, specifically Mr. Wallace, who allegedly mobilized a digital army across the U.S., especially in cities like New York and Los Angeles, to create, seed, and promote misleading or disparaging content on social media. These posts were designed to appear authentic and were reportedly fed to unsuspecting journalists to help them go viral and manipulate public opinion. The goal, she claims, was to prevent her from exposing the truth about Mr. Baldoni. According to her, they orchestrated a coordinated campaign to destroy her credibility and boost his, something she labels as unlawful retaliatory social combat. Interestingly, in that deposition request, she doesn't mention sexual harassment or a smear campaign. Instead, her claim centers on a breach of contract, specifically, a rider attached to her agreement to return to work. This rider allegedly prohibited any form of retaliation, including disparagement. She claims it was violated by Wayfair employees and agents through a covert press and social media campaign. She also asserts that Mr. Wallace played a role in breaching this rider and orchestrating a campaign to damage her reputation, shifting the narrative onto her and her husband, Ryan Reynolds, and away from Baldoni. Ultimately, she sought Wallace's testimony regarding his knowledge of this rider and whether he was aware of the non-disparagement agreement. But again, she wasn't claiming sexual harassment occurred. As the judge noted in Jed's case, simply having knowledge of something doesn't mean you acted on it or had a legal duty to do so. If there is a so-called conspiracy, merely discussing it or being aware of it doesn't amount to anything legally, unless there's actual evidence that a conspiracy occurred, and more importantly, that it targeted or took place in New York. Now, the legal question becomes, does this contract hold up under federal law when it pertains to issues like sexual harassment and retaliation? That's ultimately for the court to decide. Early on, many in the media correctly recognized that the core issue here wasn't necessarily about harassment, but rather a potential violation of a non-disclosure agreement, NDA. The question is, did either party breach their NDA by speaking publicly? Did Blake violate her NDA, or did the production team violate theirs? NDAs are mutual, and she was undoubtedly under one as an actress involved in the project, which would prohibit her from disparaging them as well. Back in January, she told the court that her reason for requesting testimony from Jed, after accusing him of orchestrating events against her, was to avoid unnecessary litigation. She pointed out that there's an increased risk of frivolous lawsuits in a situation where Mr. Wallace's attorney, Mr. Friedman, had repeatedly threatened legal action against anyone who might pursue claims based on the allegations in her complaint. This concern was heightened by the involvement of another defendant, Mr. Sarowitz, who had previously stated at the film's New York premiere on August 5th that he was willing to spend $100 million to ruin Blake Lively and her family. However, the judge made it clear that such statements, while disturbing, are not evidence of a conspiracy. They are simply statements made to a witness. No actionable proof was presented that a coordinated effort to harm her took place. Furthermore, throughout 2024, Mr. Sarowitz, founder and active director of Ploidy Holding Corporation, sold nearly $100 million worth of company stock. Blake's request for Jed's deposition was framed as a way to help her decide whether further legal action was warranted. She argued that obtaining his testimony could help reduce the likelihood of a frivolous lawsuit and promote judicial efficiency, which is one of the goals of Rule 202. Ironically, despite making this argument, she later filed the lawsuit in New York without ever obtaining the deposition she claimed was essential to determine the merit of her claims. Texas law, unlike federal law, requires civil lawsuits to be supported by competent witness testimony and evidence. The Texas Rules of Civil Procedure contain strict provisions about the signing of pleadings, motions, and other legal documents. If a person files a lawsuit based on false claims or for improper purposes, such as to harass, delay, or intimidate, there are serious consequences, including potential sanctions and findings of contempt of court. This makes Texas law more robust than federal standards in these situations. Because of these legal safeguards, Blake cannot file a case in Texas with baseless defamatory claims or wild accusations unless she can prove they are true. Substantial evidence is required before even initiating a lawsuit in that jurisdiction. In a way, that's a commendable aspect of Texas law. it holds plaintiffs accountable. That's why she appears to be trying to move the matter out of Texas. As of today, she still lacks concrete evidence that Jed took any retaliatory actions against her. If she had such evidence, she would have already submitted it to the court. In fact, the judge had access to everything filed under seal, including the evidence indicating that Jed was aware of the 17-point agreement. But that alone doesn't prove he retaliated. The judge also reviewed communications with individuals like Heath and even some of Jed's emails that had been submitted in court. Despite all this, the judge was not convinced that Jed had taken any action against her in New York. Even the claims she made to support the notion of a conspiracy were found to be insufficient. They did not demonstrate that Jed knew about any coordinated effort against her, nor did they establish that any alleged actions caused her harm in New York, or that they caused harm at all. The burden of proof lies with the plaintiff. It's up to her to demonstrate that a conspiracy or coordinated effort actually occurred. Simply because someone talks about you doesn't automatically mean their comments are the reason your reputation suffered. Her entire claim hinges on the idea that others posted and amplified content portraying her in a negative light, but that content was based on her own actions and behavior. She's alleging that this was done intentionally to harm her reputation. But people were simply reacting to what they heard and saw, her own voice, her own statements. She refuses to acknowledge that her comments about domestic violence failed to resonate with the public. Instead, she blames the backlash on a manufactured campaign allegedly orchestrated by Wayfair. This is one of the reasons why the case against Jed is on shaky ground. First, she lacks any clear connection tying Jed to New York. Second, Texas has laws designed to prevent frivolous lawsuits, which may apply here. So, if she drops the case against Jed, what's next? Likely, she'll turn her attention to Melissa Nathan. She's already subpoenaed several content creators, some of whom are now responding in court, stating under oath that they were not paid, nor did they collaborate with anyone involved in the alleged conspiracy. For example, Cassidy O'Connell filed a motion to quash the subpoena and indicated she plans to file sanctions or report Ezra Hudson to the bar. Cassidy flatly denied any contact, payments, or involvement with the parties in question. She also pointed out the subpoena was filed in the wrong jurisdiction, in New York, while Google, the recipient, is based in California. By law, the subpoena should have been filed in the state where compliance is required, California, not New York. Cassidy's motion emphasized that there was no basis to seek her information, no evidence of her contact with anyone relevant, and that the plaintiffs failed to follow the correct legal procedures for unmasking anonymous internet users. Her argument was well-structured, though at times sharply critical of both the judge and Ezra Hudson. Shortly after her filing, Ezra's team submitted a response. But rather than addressing Cassidy directly, they shifted focus. Instead, they cited that Melissa Nathan had listed content creators she spoke with and filed it under an attorney's eyes-only AO designation. This seemed like an attempt to avoid directly countering Cassidy's motion while addressing similar concerns indirectly. They also implied that Cassidy and Andy Signore were being paid by TAG or Wayfair, a claim that both deny. The aim appears to be reinforcing the idea that TAG has coordinated with these creators. Their response mentions that TAG provided a list of individuals who publicly discussed the lawsuit, allegedly at TAG's direction. But simply speaking with a content creator or giving them background doesn't equate to directing or scripting their coverage. Moreover, TAG's response was designated AEO, supposedly to protect trade secrets. However, no specific facts were provided to explain how naming third-party individuals qualifies as a trade secret or how this information could harm TAG, especially since many of these individuals have already made public statements about Ms. Lively and the case. This recurring theme, that content creators are acting on behalf of TAG, lacks substantiation. It's like suggesting Ryan Reynolds following a pro-Blake account like the ex-patriarch on TikTok means he's feeding them information. Just because someone speaks with a creator or a creator receives a statement doesn't mean they're working on that person's behalf. It could just be an independent journalist seeking a comment for a story. Let me know your thoughts in the comments. Thanks for tuning in. We'll be back soon.